Welcome to the People's Law School. This is the segment on Social Security disability claims. This is brought to you by the McCracken County Bar Association and the West Kentucky Paralegals Association. Joining me today is Mrs. Donna Thornton-Green, who practices here locally in Paducah with William Kitchen. Donna is a very experienced Social Security practitioner. She graduated from law school some 18 years ago at the University of Louisville. She spent 3 years as the senior staff attorney with the Social Security Administration Office of Hearings and Appeals here locally, and ever since 1992 has been a regular practitioner specializing in Social Security disability claims. I'm Craig Housman. I've been at it a little longer than Donna. I've been practicing in personal injury work and workers' compensation and Social Security here in Paducah for the past 33 years. I guess a good place to start, Donna, is what does it take to be disabled by Social Security standards?
Well, it's a long process for most people, Craig, but the definition of disability is the inability to perform substantial gainful work activity because of a severe or combination of severe impairments that are expected to last 12 continuous months or in the person's death. And that's probably the rare occasion. Most times it's whether the condition has lasted or will last 12 months.
So it doesn't matter how severely you are injured or how sick you are, if you get over it within less than 12 months, you're not eligible for Social Security disability benefits.
That's correct, and that's one of the big issues is when to apply for disability. And for most people, that's the number one question. And if your doctor has told you that your condition is severe and you're not likely to return to work in the near future, you don't have to have an exact timeline, but if it's expected that you're going to be off for some time, then you can go ahead and apply as early as the first day that you've been injured.
Actually, it makes a considerable difference when you apply, depending on whether you're talking about the Supplemental Security Income Benefit Program for the disabled, or whether you're talking about the regular Social Security disability benefit program under Title II, does it not?
It does, Craig, and as obviously there are several parts to the disability or packages that one can apply for under Social Security disability.
Okay. One of the things that I hope our viewers will understand is that these are two different programs, both run by the Social Security Administration, and they sound alike, so people get them easily confused. One of them requires that the worker has paid so much money into the system over so long a period of time. It's sort of like a great big government-run socialized disability insurance policy. You've paid in payroll deductions for years. Now, because of an injury or illness, you're disabled, and you want to get back benefits from the government based on the amount of money that you've paid in. The other is the Supplemental Security Income Benefit Program, and for that program, the worker does not have to have ever paid in anything into the system, but they have to be disabled and poor. Is there a difference in the definition of disability between the two systems?
No, and that's what's confusing for a lot of people, is it's the same definition of disability. You have to show that you can't perform your past work. If you've not worked, that you can't perform work that may be available considering your age, education, and past work experience. It's a complicated process, and for both, you make the same application. Your case goes to the state level initially, and that's called the initial application. And there, a disability examiner will gather medical evidence. You may be sent for a consultative examination, which basically is you're referred to a physician that Social Security has hired to give an opinion about the severity of your medical condition. Social Security is supposed to gather your medical records to assist in a physician review of either your medical evidence that's presented from your doctor or the hospitals that you've been in, or the opinion from the Social Security doctor. At that point, Craig, in Kentucky, I think the percentages are, at that level, the initial level, about 60% are denied. So that's a very hefty portion of denials, and of those denials, only I believe 25% will go to the next step. Would you like to discuss the next level?
Oh, the next level is basically running the same file back before the same organization, the Kentucky Division for Disability Determinations, and they at least run it past a different physician to read the other doctor's records. I once upon a time took the deposition of one of those folks and asked him how much time he spent per file, and it was about 10 minutes. So it's really important that the person who's applying for disability benefits appreciate the need to get his or her physician to try to get as much information into that file as possible and to express any opinions they have. I know a lot of the physicians that I've talked with in the process of handling these claims say, oh, they don't pay any attention to what I say anyway, and so they don't bother to fill out the forms. And that is really, really, really not the truth. While they may not pay much attention to what your treating doctor says at the first two steps, when you get a little further down the line, what your treating doctor has put in the record makes all the difference in the world. Has that been your experience as well?
It does, and I think what happens is most people become confused with a statement from their physician that you're disabled. It's not the mere statement that you're totally disabled, or your physician suggests that you file for disability that's going to win the case. It's the type of evidence that's submitted. It's the information about your medical condition and the diagnosis and how it limits or affects your ability to perform work-related activities. At the reconsideration level, I don't know about you, Craig, but sometimes I just consider that step a rubber stamp. Yeah. The percentages are very high. I think it's 90% of the people who make it to the second level are denied, and only about 10% of those people will actually appeal. So the numbers, the system is set up, or at least the numbers work out that it's very advantageous to the government to appeal, to have this three-stage set up, because more people are going to drop out, and the numbers are very few that follow it through. But the success rate for those who follow through and hang in there is much better, especially if they have an attorney representing them. Okay. And at the second step, the reconsideration level, I want to give you some figures. A big question is time. The average national processing time at the state level, at the initial level, is 106 days. The national average at the reconsideration level is 94 days. So that's a long time for most people. And then you're out of the state system and you're into the federal Social Security system, and you get a hearing before a judge. And what's been your experience, what the hearing process is like?
Well, I've shared your experience that the prospect of success at the second step doesn't justify the wait that you have to experience there. And it's basically an exercise in futility, and I think it's recognized as such by the Social Security Administration. I think the current plan that's on the books with the current Commissioner of Social Security would eliminate the reconsideration step. Once you get to the hearing stage, you know, I think if we don't count the United States Supreme Court, I think there are 8 possible steps in realistically processing a Social Security disability claim. And of those 8 steps, there is only the one where the individual who is applying for disability benefits gets to look at and talk to the human being who makes the decision whether or not they have satisfied Social Security's disability criteria. It's the only one. every other level of decision making, it's done based on a paper review. Somebody gets a folder, and of course now we're starting to try to learn how to do that all electronically, but it's still the same basic process. It's depersonalized. The decision maker doesn't get the sort of human being to human being interaction and information that is imparted by the way the person looks and comes across and walks. And of course sometimes that's helpful to the claimant, sometimes that's harmful to the claimant, but either way I think it is a more valid decision. In terms of how the hearing process actually works, I've been doing it for 33 years. I've been in front of, I bet, scores of different administrative law judges. And while there are certain similarities, there's a great deal of difference that I have found depending on the particular administrative law judge which that person happens to have drawn. Some of these are really laid back and almost informal, and some of them it almost seems like Torquemada and the Inquisition.
I would definitely agree.
Okay. But one of the advantages of practicing in a community the size of Paducah is, for the most part, the lawyers who handle these sorts of cases in the community have a pretty good idea of what the individual judge who is assigned to that case is likely to want to see in the manner in which he or she conducts the hearing. And that can have a big advantage. And while we're on that subject, could you just sort of explain to our listening audience what sort of difference, practical difference, a lawyer makes in terms of the outcome of the decision process at the third step?
Oh, I think it makes all the difference in the world. Years ago, I could tell someone that they didn't need an attorney, that the medical evidence, the proof was so strong that they just hung in there, they should be successful. But it's while it is supposed to be an informal setting, as you've just mentioned, a lot of times it's not. And there are a series of questions that most of the judges are going to inquire into, and how the claimant answers those questions about their daily activities relate to what jobs the judge is going to be able to conclude that the person is able to perform. And oftentimes there's a vocational expert present at the hearing, and occasionally there's a medical expert present at the hearing. And while those individuals don't typically ask questions of the claimant, pretty much the person's entire work history, their medical problems, and their daily activities are discussed at the hearing, so that the judge can make some assessment as to whether this person could perform their past work or other work that exists. It's like you're going before a judge, and it's important to have an attorney there assisting you, because the attorney can bring out the positive points about your case or clear any misconceptions that may be in the file. And part of the problem too, Craig, that I've seen through the years is when people go at this on their own, there are so many forms that are filled out at each level, and how those forms are answered, the information that's provided, whether the person understands how the information is going to be used, and what really the questions are addressing, the issues that are being addressed. It ends up coming back later on in the case at the hearing level. That entire file is there, and everything that person has said is subject to question and review. So if you have an attorney, they can at least guide you through that important part, and that's the written documentation that's presented, as well as the testimony at the hearing.
If someone's already had a hearing and received a negative decision from the administrative law judge, are there adverse consequences so far as being able to add new evidence to try to show that the judge was mistaken in his conclusion?
Well, you're pretty much, the record is closed at that point. However, you can appeal the administrative law judge's decision to a body called the Appeals Council. At that point, it's basically you have to have the ability to argue your case, and certainly that is where an attorney is is most beneficial because they understand the law and the evidence that's been presented. It's very hard to get new evidence considered at that point. Certainly, the time to hire an attorney is long before the hearing level. You want to go in that hearing represented. And one thing I tell my clients, if the money is a benefit that's important to you or the medical benefits, then it's worth having an attorney. The fees are statutory. Attorneys are only paid out of the back pay, and that's 25% for the most part. And most attorneys, I'm sure, including Mr. Housman, we limit our fee to $5,300, which is the maximum before an administrative body. Obviously, if you have to sue Social Security in federal court, then the fees are generally 25% of the back pay. But if it's money that you need for your livelihood and your family, then it's important to have an attorney who can act in your best interest.
One of the things that you mentioned a few minutes ago was talking about the person's past work. One of the questions that I get asked so frequently is somebody that worked at a sewing factory, and they say, well, that shouldn't count. That factory closed down. All those jobs have gone to Mexico or the Philippines or somewhere else. Just as an example of some of the sometimes harsh regulations that the person seeking benefits has to deal with, does it matter that the job that the person has done in the past does not exist anymore?
No, it does not. Unfortunately, Congress's standard is the national economy, and hiring practices and what may be available in your local vicinity is not part of the equation. It's whether those jobs exist in significant numbers in the country, and Social Security doesn't care that you might not be able to go and get that sewing factory job again.
Yeah.
Locally, and they also don't care. The one question I get so often is no one will hire me because I've had back surgery. Again, those are hiring practices, and they don't enter into the decision process for the Social Security Administration.
Right, and that's a real good example of the sort of difference that can be made in the way the hearing testimony comes across. Is the person who doesn't realize that there are certain artificial rules that Social Security has to follow because that's what Congress told them to do. Those folks who go in there and give explanations like, well, gee, nobody will hire me. I mean, you got a very limited amount of the judge's attention span, and you're wasting it by talking about things that he or she cannot take into account. Whereas instead, if you're asked about why you couldn't go back to work at the Merit Clothing Company or something like that, matching swatches, to say that I can't sit that long, or that I've got to have breaks more frequently than they would allow, or I miss too many days because of flare-ups with my problems, those things matter. The fact that the job doesn't exist anymore does not. And frankly, if it's a job that you've done in the past, it really doesn't matter what the numbers are nationwide. I remember there's been a Supreme Court decision within the last 2 or 3 years where some poor soul had been an elevator operator 14 years before his hearing. And the Social Security Administration said if it was a job you've done in the last 14 years, it doesn't matter that there aren't any elevator operators anymore. If you can still do one of the jobs you've done in the past, you lose. Mm-hmm. And so it's a matter of knowing, what the rules are, where the traps are, and being able to stay away from the traps and take advantage of the few remaining favorable artificial rules that Social Security has. And while we're on that subject, what are some of the favorable things that they have that tend to be a little arbitrary?
Well, one important factor that helps most claimants is the administrative law judge and the Social Security Administration must consider all of the person's impairments, mm-hmm. even if one doesn't disable them or is not the reason they're not working. So if you have learning disabilities, or if you have psychiatric problems, in addition to, while those problems may have not prevented you from working in the past, But because of other problems now, they either are more intensified or the point is that Social Security has to consider everything that that person is dealing with from a physical and a mental standpoint.
One of the other things that strikes me as a little artificial, and I guess it's because they just draw a line that's sort of arbitrary, is like you get some benefit from being older. And since
Yes.
now I'm 57, Social Security considers me of advanced age in their regulations, and that has some considerable significance. Basically what it boils down to is once you hit certain age plateaus, there is a benefit to you. The hurdle is lowered a little bit in terms of what you have to prove to get to satisfy them that you meet the disability standard. One of the things that a lot of people are concerned about is medical care, and we started off talking about the two different systems in Social Security. Is there a difference in what medical coverage is available, contrasting what someone who's eligible for supplemental security income benefits receives and what someone who is eligible for the regular Social Security disability program receives?
Yes, if you're eligible for disability insurance benefits, either as a disabled worker, a disabled widow, widower, or a disabled child, then after the initial waiting period, which is 24 months, you're eligible for Medicare. And with supplemental security income, as long as you're entitled to $1 in benefits, then you're eligible for the state medical card. And that is effective with the date that you're found disabled or the date of the application for supplemental security income benefits. So those are two very important types of medical coverage that are available with disability benefits. One question that I also have that comes up quite often is for those persons who are receiving workers' compensation benefits and are considering filing for Social Security. I understand you've got a substantial workers' comp practice, Craig. Is there any prohibition or reason not to pursue Social Security if you're drawing workers' compensation?
The fact that you're drawing workers' compensation by itself is not at all inconsistent with being entitled to Social Security disability benefits. The considerations are you still have to remember that the disability has to be something that would completely or be completely disabling by Social Security standards, and it has to last or be expected to last for 12 continuous months. But if it does, there's nothing in workers' compensation that says you can't draw Social Security and this at the same time. There's nothing in Social Security that says you can't be eligible for Social Security benefits and workers' compensation at the same time. There is an offset so that workers, and this is fairly complicated, and it's real complicated. I wind up dealing with these problems all the time. But basically, the theory is sound, and Congress set it up to where the person who is injured on the job and is totally disabled is restored to something that's pretty close to what their actual earning capacity was before they became disabled, but they aren't improved. In other words, their living standard, how much money they've got coming in, does not grow. Because before Congress made that change, people who were hurt on the job and totally disabled and eligible for Social Security disability benefits were receiving tax-free the same Social Security benefit they would receive had they turned full retirement age the day they got hurt, plus in most states they were receiving 2/3 of their average weekly wage. And at that point in time, which was back in the late 60s, there were no taxes, no income taxes on either benefit. So folks who fit that category, particularly people who were at the lower end of the earning spectrum, were drawing more money tax-free than they had ever made in their lives. And that was the basic problem that Congress sought to solve. And they did if you look at the big picture, they did a pretty reasonable job of solving that problem. But in the effort to be fair, they made it very complex, and that makes it a bit of a struggle.
Yes. I think one last issue that we should cover is, a common question is, can I be partially disabled? And without a doubt, you must be totally disabled to draw Social Security benefits.
Well, that's true in a way and not true in a way. And I don't want to argue with you, but basically there's nothing inconsistent with still being able to work a little bit and receiving Social Security disability benefits. In fact, one of the things that I brought with me was one of their publications that they have on trying to encourage folks who are receiving disability benefits to try to get back into the workforce at least a little bit. And I think you can earn, like this year, you could earn up to a little over $800 a month and still not be disqualified from Social Security because of your earnings. But from the standpoint of saying, like in workers' compensation, the person's got a 25% disability, well, can I get 25% Social Security? You're absolutely right. It doesn't work that way. It's either 100% or nothing as far as the Social Security Administration is concerned.
Correct, and even you don't have to be totally unemployed to file. You can still be drawing or earning, as you indicated for this year, the $860 a month. It's not, that is a level, a critical level that's not considered substantial gainful work activity. So it's very important to consult an attorney in deciding to file. I'm sure you do as well, offer a free initial consultation to assist persons in deciding whether they should pursue Social Security.
One other thing that is unfortunate, the person cannot keep on working at their regular job, making regular sums of money until they get a decision from Social Security to say whether or not they're disabled. In other words, you can't find out ahead of time whether or not you qualify before you stop working, unless the job you have is something that earns so little money that it's not considered substantial gainful activity. And it always seems to me it's like, you know, telling somebody to jump off a bridge without knowing how deep the water is the way the system seems to work now. And it's unfortunate, but that's the way it is.
It is. In most cases, the average processing time, if you have to go to the hearing level, is 294 days. So you have to be able to manage to get through that process time financially, and it's hard for most people.
Yes, it would be hard for virtually anyone. And of course, if somebody's thinking about whether or not they should try to seek Social Security disability benefits, I think the first person to talk with is their physician. And if he thinks it's a good idea, then the second person to touch base with is an attorney to see whether or not they would satisfy the technical criteria. We want to thank our audience so much for listening to us as Donna Thornton-Green and I, Craig Housman, have been discussing the ins and outs of Social Security disability claims. And thank you for watching us again on the People's Law School.